The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, welcome to Maryland Volunteer Lawyer Services Third Thursday webinar. This week we're talking about avoiding pro bono for low-income clients, and we have Alice Young here. Alice Young is an associate at Nusinov Smith. She joined the firm in 2012. She manages a wide range of estate administration matters, including probate of small and regular estates, coordination of appropriate estate-related tax filings, and managing filings before the Orphans Court throughout the state. Alice Young is also the recipient of our Partner Award at our Celebrate Pro Bono event in 2015, and we're very excited to have her here. So with that, I'm going to turn it over to Alice so she can tell you more about avoiding probate.
Thank you. And thank you all so much for joining us here today on the webinar. I do want to mention that I am downtown at MVLS right now in the belly of the beast, but the hard work that MVLS does for pro bono clients is done out in the field by attorneys just like you who take on volunteer cases and do pro bono work, because we all know that folks, even when they don't have means to pay, do need representation on legal issues. So we really appreciate you being here for the webinar today, and I hope that you do consider taking some cases, because you will be able to help estate planning clients avoid probate with some of these pieces of information, and also on the other topics that of the areas of practice that you work in. So we are going to talk today about avoiding probate for low-income clients. We are also going to put you in a position of, I am not clicking forward.
Oh, click down.
There we go.
There you go.
May I?
Yeah.
Super. The avoiding probate for low-income clients is a topic that's not only going to help you assist MVLS clients, but it'll also help you assist any other clients that you have, as well as you will become the most popular person at your family gatherings, because the one thing that binds us all together is death and dying and the transfer of property on that occasion. So you will be able to help your personal clients, you'll be able to help pro bono clients through MVLS, and you'll also be able to carry on terrific conversations with your friends and family about how they too can avoid probate. The topics that we're going to cover today include deeds, how to transfer real property outside of probate, pay on death accounts and transfer on death accounts, how to transfer bank accounts outside of probate, beneficiary designations, and then we'll end up with the MVA, the new MVA title transfer through beneficiary designation that came into being in 2017. We're going the other way. Before we start, I just want to throw out a warning here. Even if a client has low income or few assets, they're still a client with all the other attendant issues that every client brings to the table. When doing estate planning, we do have to pay particular attention to the relationships of that client, the relationships he or she has to her family and friends. Estate planning involves lots of issues about who you trust and choosing people for agency designations. You want your notes for your planning clients to be rich with detail on how they interact with the people around them and who they trust, so that if ever it comes into question, we do have a record of the things that client talked about with you. And you want to ask about financial circumstances, not just of your client, in other words, their own income, assets, and means-tested benefits, but also the financial circumstances of any potential beneficiaries. You have to counsel your client that a gift that they leave to somebody, a loved one, may jeopardize that loved one's means-tested public benefits. Estate planning, even in the low-income context, it does have potential pitfalls, and we want to be aware and make sure that we explore all of the clients' personal details and then the details that they have available of the people to whom they may be leaving things, or the people whom they may be trusting with certain agency activities. Just take this opportunity when you're with your client to be curious and make sure that they understand the work that you're doing and the impact that this work may have on the people around them. So to that end, I just want to touch briefly on some ethical considerations for estate planning. Who is the client? What conflicts of interest you may commonly encounter, and what type of capacity issues might come up for clients in the planning scenario. And again, this is not exhaustive. We're talking today about planning to avoid probate, but I do just want to let you know that when you're doing estate planning with a client, the client is the person whose planning you're doing, and you want to make sure to have a portion of the interview be with the client alone, and make sure that the client understands what the meeting's about and what the attorney-client relationship is with that pro bono client. It's common in estate planning for a client to be brought to you or for the meeting to be arranged by a loved one or another person in the client's life, but that relationship that you are establishing is with the person for whom you're doing the planning. One common conflict of interest, any attorney in a attorney-client relationship is representing or advocating for one person. Oftentimes spouses get involved in estate planning together, and so the Maryland Rules of Professional Conduct require that the conflict is waived by consent in writing. So this is just an example of a portion of my engagement letter that I send out to spouses. When they are coming in for estate planning together, they must waive that conflict in writing, and so we have a record of that in the file. And with estate planning and any other transaction, the transaction can be overturned if the person lacked the ability to make that decision in the first place. So I'm just going to touch briefly on capacity and give a sense of what you're looking for when you have somebody who's making decisions about transferring property during their lifetime or at the end of their lifetime. Typically what we're looking for is the ability to understand a contract. So financial powers of attorney, advanced medical directives have the same level of capacity required as a contract, and a will has a lower level of capacity. So when you're giving away your property at death, you actually, under the law, you must have enough capacity to make that transaction, but not as much capacity as you would need to make a gift during your lifetime or enter into a contract. And the reason this is important is because often with pro bono estate planning or taking on clients to help avoid probate, like we're talking about today, the meetings might be brief, or you may not see the client more than once. And it's important just to be aware and keep detailed notes of your meeting to make sure that you recognize that if you get the sense that a client is unable to make a will or unable to enter into a contract, that you want to make a note of that and perhaps delay any other action until a follow-up meeting to get a better sense of it, or to contact somebody with more experience in the area to give you some guidance on what things to look out for. So just as a brief overview, talking about who the client is, identifying some common conflicts of interest, and keeping an eye out to make sure that the person you're providing services to has the ability to take the steps that you're advocating for. And in estate planning, often there are scenarios that involve varying levels of physical ability, perhaps levels of changes in the levels of cognition. And we just want to make sure that if we're in a situation where we don't know for certain, that you get some advice on how to handle that particular client. As a spoiler alert, again, today we're talking about how to avoid probate, how to avoid having property pass under the terms of a will. But I do believe that every person needs a will, so we're going to wrap up the talk at the end of the PowerPoint, and we're going to talk a little bit about wills. Again, this is an exciting topic, and I don't want to reveal too much before I want to keep you on the edges of your seats. But we are going to follow the talk about avoiding probate by talking about all the reasons you do need a will anyway. To that end, we're going to get into some of these Latin terms that you may or may not remember from property. Per stirpes, and I just want to point out in this chart there's the definition up at the top is if you die without a will, intestacy, and then down at the bottom is what happens if you die with a will, testacy. So you can die intestate without a will, or you can die with a will, which is called testate. And per stirpes is important because in some of the contracts, some of the language that we talk about as we go through, you're going to see the phrase per stirpes. It simply means taking by the roots. The Latin is by the roots, and it means that if you die and you have 3 children and you leave your estate per stirpes, then those 3 children will take equally. If one of your children predeceases you leaving children, then that child's children will take his or her share. So if you die and you're survived by 3 children, each child gets a third. If you die and you're survived by 2 children and the grandchildren left by one predeceased child, then those grandchildren will split the predeceased child's 1/3 share. It gets a little bit mathy and we're reaching way back into our property law, but I do want to just point out the phrase and make sure that you have a sense, and you can always refer back to the PowerPoint or your notes to say that when you see per stirpes, it simply means that it will be divided at whatever the level designated into equal shares. This is distinguished by representation, where all members of this might be getting a little bit too academic, but by representation means that instead of being divided by the first level into equal shares, it's divided on the level where there's at least the one survivor. So the example here is if the decedent had no surviving spouse, children, parents, or siblings, then the intestate heirs are the decedent's first cousins. But if no first cousins survive, then the division into equal shares takes place at the level of the first cousins once removed. And if you've ever been sitting around the water cooler and talking about your first cousins once removed or your second cousins 3 times removed, rest assured that there is a chart on the Register of Wills website, and you can print out that chart and carry it with you everywhere so that you and your friends can put to rest what all these definitions are for. Next, we get into if someone survives me, and both the intestate and the will statute require somebody to survive you by 30 days in order to take their share. You can always change that under a will, but you can't change it if you don't have a will, so that's another reason to have a will. And the on the side here, it'll say the anti-lapse statute. Maryland has an anti-lapse statute, which indicates that if somebody is supposed to receive something under a will and they fail to survive the person who made the will, then that share, whatever they're supposed to take under that will go to the people who would have taken that share, whether that legatee died testate or intestate. So it actually goes according to that legatee's own estate plan, which is important for, when you have to counsel a client on what happens if, you want to make sure that you understand some of the contingent scenarios so that you can talk them through what's likely to happen. So here in the black quarter of the circle with the arrow, it says subject to administration through the Register of Wills for the county in which the decedent was domiciled at death. That's the probate estate. So if you have a will or you lack a will and you die and assets pass through probate through estate administration, then that's the portion of assets that will pass that way. The red circle is what we're talking about today. The red circle is everything else, things that pass by trust and non-probate contracts, operations of law. So I know that that's what we're here to talk about, and I know you're very excited about it. So we'll move on to the meat here. Transfer of real property by deed. So there are a couple ways that deeds can transfer real property where you don't have to pass the real property through probate. We're going to talk today about life estate deeds and joint tenancy and tenancies in common. And these, again, are some of those property terms from way back in the first or second year of law school that you may have set aside in your mind thinking you'll never have to think of them again. We are going to think about them a little bit today just to distinguish them and make sure that when you're sitting with your client, you can provide the information the client needs to make a good decision. So a deed, and I'm sure that many of you have worked on deeds before. Deeds can be used to avoid the cost and time of probate by changing the deed to say a parcel of real property goes to so-and-so on my death, but they also cost time and money to prepare and record. So when you're counseling a client, you can say, you know, we can do this deed, but you got to pay $60 to record it in the land records. Or we can not do this deed, you save $60, and then the next person who has to make the actual paper transfer of the real property, they have to bear the cost of the $60. And I counsel my clients on this all the time. We can make a life estate deed, I'll charge you this much money for it, and then there's the cost of recordation. Or you can just let your children or grandchildren bear that cost themselves. And sometimes clients say that they prefer to pass that cost along to the next in line. So cost is something to consider when we're talking about transferring real property by deed, because if we record a new deed, there are immediate costs associated with that. The first type of deed we're going to talk about is a life estate deed retaining powers to alienate. A life estate deed creates two owners, the life estate tenant and the remainderman. There's a term from law school, the remainderman. So the life estate tenant retains the right to possess the property for her life, and on the life estate tenant's death, the remainderman owns the property without the need for probate. This deed is essentially an estate planning tool. The person creating the deed retains the powers to sell, mortgage, take back, or give away, but not devise by will. Meaning the life tenant can destroy the interest held by the remainderman, and so the transfer is not a complete gift. That's important for a number of reasons, and we'll get into those. But this is an example of the language used in a life estate deed. I promise not to read it all to you. But here, the grantor reserves, this is language that is inside the deed that you're preparing for life estate retaining powers. The grantor reserves herself the ability to live in the property for her life, but the full power and authority for her lifetime to sell, convey, and dispose the property in fee simple and retain absolutely as her own all of the proceeds thereof. So that's retaining all the power to revoke that transfer to the remainderman. And that's important because most people don't want to give their property away during their lifetime. Most people want to keep their property for their own use, and they want to make an estate plan that will make it easy for their loved ones after they die, but they don't actually want to give their stuff away. So this is the life estate retaining the power to alienate, which means that you can always revoke that. A life estate, on the other hand, without powers to alienate, does the same, all the same basic things, creates the two owners, the life estate tenant and remainderman. The life estate tenant retains the right to possess the property for her life, but on her death, the remainderman owns the property immediately. There is no need for probate. However, by foregoing the powers to sell, mortgage, take back, or give away the property, the life estate tenant cannot destroy the interest held by the remainderman without the remainderman's participation, and so the transfer is a complete gift. It does implicate gift laws, and it is something that a client in this situation must be counseled on. And because it is a complete gift, transferring the interest to the remainderman, at least the remainder interest to the remainderman, this is often used as a medical assistance planning tool and not just for estate planning. Where that life estate deed retaining powers, it's just something that we do to avoid probate. The life estate deed without powers to alienate, this life estate deed can be used as a medical assistance planning tool because you are making a complete transfer of a remainder interest while the decedent, while the life tenant is alive and before death, which means that you're transferring an asset to another person and triggering the 5-year look back. So this at the bottom is an example of the language that would be used in a life estate deed of this kind. but reserving unto the grantor a life estate in the property for the term of her life without liability for waste. So this simply says she gets to live in it for the rest of her life. But if she wants to revoke that, if she wants to change the ownership back to just her, she needs the consent of the remainder person, and that can be a little tricky because most people don't want to give up property once it's been given to them. We talk a little bit about joint tenancy versus tenancy in common. Here I'm talking in the context of real estate, a deed transfer, but joint tenancy and tenancy in common are applicable across the spectrum of ownership. So we're also going to talk about it in the context of bank accounts and cars and things like that. But a joint tenants own undivided fractional interest in something, and joint tenants carry the right of survivorship. So when one joint tenant dies, the remaining tenant owns the deceased tenant's share. Unlike tenants in common, who own undivided fractional interest in something, but without rights of survivorship. So if somebody owns half of a house as a tenant in common, the deceased tenant's share passes through his or her estate to his or her beneficiaries. And so you may end up, if a brother and a sister own a house as tenants in common, and then the brother dies, the brother's estate will own half that house, and then the brother's takers, whether it be his children or somebody else, the brother's takers will own that house now with the surviving tenant in common. It can complicate things considerably, but it is also often the right way to do it. So it's just something to be aware of, joint tenancy versus tenants in common. This is an example of a deed, some language in a deed of joint tenancy that was done to avoid probate. Here, the life tenant, and it's also overlap with the life estate deed. So here, the life tenant retained full powers of disposition and gives to the daughter and son as joint tenants and not tenants in common. The paragraph at the bottom, joint tenants and not tenants in common, parties in the second part. This means that the daughter and son, on the death of the life tenant, the daughter and the son will own this as joint tenants, and on the death of the first of those tenants to die, the surviving tenant will own the whole house. And it's unusual for property to go to children like this. So I want to make you aware of it. It is an option, but it is not terribly common. The tenancy in common, on the other hand, as we discussed, does not avoid probate. So here is a personal representative's deed. It's a deed done on to close administration of a parcel of real property and transfer the real property to new owners. Here, the personal representatives of the estate grant to the children, the son and daughter of the decedent, as tenants in common and not as joint tenants with rights of survivorship. So each of the children in this instance owns a 50% undivided interest, and each child's interest will pass through that child's estate on the child's death. So it makes a big difference to the children's estate planning that they can plan for the disposition of this asset, instead of in the prior example where they were joint tenants with rights of survivorship. They are unable to plan for how they want their half of the property to pass, because it passes automatically by operation of law to the surviving joint tenant. So we're going to talk a little bit now about financial accounts. The financial accounts, in this instance, I'm going to talk about bank accounts, insurance and benefits, things that most folks have, at least in part. And I have done pro bono work for folks who have small 401ks, small IRAs, things that they're not huge in value, but the importance of planning properly for those assets is very critical to the surviving family members. So we want to make sure to understand how to designate certain assets. We're going to talk about pay on death designation, transfer on death designation, beneficiary designation, and custodial designations where available when assets are passing to people under the age of 21. So first we're going to touch on financial accounts. I'm just going to point your attention to the Financial Institutions Article 1204 that defines multi-party accounts. And we spoke a few slides ago about joint tenancy versus tenancy in common and what that means with respect to rights of survivorship versus ownership that passes through a predeceased owner's estate. And here, the Financial Institutions Article defines how an agreement transfers a financial account on death. It says a provision in an account agreement for a transfer on death in compliance with this section is non-testamentary and shall be effective according to the provisions of this section. Transfers pursuant to this section are effective in the form and manner prescribed by this section and are not to be considered testamentary. So we're seeing the overlap between financial institutions and estate planning, that word testamentary, and what that means is death. So this section is non-testamentary, means that on somebody's death, an account ownership is changing, but it's not governed by that person's will, and it's not governed by the provisions in the Estates and Trusts article. It's governed by what's in the content of that financial account contract. Just for trivia purposes, I put here at the bottom the legislative intent. This act is intended to alter the common law, including Wayland v. Mulholland and Mulholland v. Wayland and their progeny. Up until 1992, when this Financial Institutions Article was adopted, this provision of the Financial Institutions Article, there was a long line of case law, 100 years worth of case law, trying to describe reliably how financial accounts pass on the owner, on the death of a joint owner. And there were things like convenience accounts and trust accounts and accounts for the benefit of so-and-so. And this statute is intended to sort of wipe out all of that case law and provide clarity, because the transfer of bank accounts on the death of an owner it should be reliable. It should be something that we know what's going to happen. When the account is titled jointly with A and B, we should know that that means that A will be the sole owner on the death of B, or B on the death of A. But the case law had become quite tangled because people, if we know nothing else about humans, we know that they like to fight about money. And when you have an account and you can make an argument that it should be yours on someone else's death, you're going to make that argument, and sometimes they won. So the legislature, in its wisdom, put together financial multi-party accounts statute that should be reliable, and for many years it has been reliable. So in 1992 they created this statute. We believe that a joint checking account and a joint savings account will go to the surviving owner on the death of the first joint tenant to die. We believe that pay on death accounts will go to the designated pay on death beneficiary. And we believe that trust accounts survive the death of the beneficiary because a trust is put in place for the benefit of a beneficiary, but on the beneficiary's death, they're remaindermen. So for these accounts, joint checking and savings, accounts that allow for pay on death designation, these accounts on multi-party accounts, a party includes someone who has authority to make withdrawals and excludes somebody who is a trust beneficiary, a POD payee, and a convenience person. So if you own an account jointly with somebody, then on the death of the first tenant to die, the surviving tenant or tenants are the owners outright of the account. So this has been the case for 25 years, and in the black box at the bottom of the screen, I just want to point out one recent criminal case that has thrown my bar into disarray. This is the case of Wagner v. State, where a father had an account in his own name, and he added his daughter's name to the account, which pre-2014 would mean that they are co-owners, and she would be the sole owner on his death, he would be the sole owner on her death, and we thought that meant that they own the asset within the account together, jointly. But in Wagner v. State, the daughter stole money out of dad's account. Well, the daughter stole money out of the account titled jointly with dad and the daughter, and she was convicted of theft because the court found that the account was jointly titled, but the assets within the account were dad's. And the relevance to non-probate planning, to planning to avoid probate, is that we often talk to clients about bank accounts, how to title them, and putting somebody else's name on an account versus having an agent under financial power of attorney to have authority over the account in order to assist an aging relative with financial transactions, but not to transfer ownership altogether. And I think it is, there's a heightened level of obligation on an estate planning attorney or somebody providing this counsel to talk through with the client what it means to have a multi-party account, what it means to have joint owners on an account, what the consequences for estate planning purposes, which is on the death of one of the tenants, the surviving tenants owns the account outright, and what the alternatives are. Alternatives being, if you just want your child to have access to the account in order to help you, in order to write checks on your behalf, to make sure your bills get paid, to help you out with the basic financial management that you need, to stay in your home or to retain control, then you may wish to do a financial power of attorney at that bank, nominating an agent to act on your behalf instead of adding a child or another loved one to the account, which complicates the ownership, creates a survivorship issue, and also allows them access to your money for their own purposes. And it is only it's one of those issues that you want to be able to talk through with your clients so they understand the implications. So just for example, I did planning recently with a client who has 2 adult daughters, and both the daughters were involved at not the first planning meeting, of course, which I had solely with the client, but at the second planning meeting. And at the first planning meeting, the client told me that she had added her daughters to her bank accounts as joint tenants, both her savings and checking. And in that instance, I thought it was fine because I was, again, meeting with the client alone. At that first meeting, the client described what she had already done, and during the course of the meeting, she also said she wanted both of her daughters to be her agents on her financial power of attorney. So she was building into her estate plan a system where both of her daughters would be treated equally. I explained to her that if one of her daughters died before she did, then she and her surviving daughter would be the owners of that account, and that may effectively disinherit the children of the first daughter to die, because then if mom dies after that, then the surviving daughter will be the sole owner. And she was confident that her daughters would take care of one another's children. It's an unusual situation that children don't fight about money and try and disadvantage each other. But in this instance, the client had the confidence that her daughters would deal with one another honestly. And there's an advantage when the 2 daughters both have access to viewing the statements and access to the account, that they keep one another honest, so that it's not just one child having access to mom's account and not having the oversight of another child. So in that instance, it seemed like they thought it through, and the client was comfortable with that. That is not always the right course of action. So you want to be able to walk through with your client the different possibilities and scenarios, so that your client understands what's going to happen, not just on the death of one of these folks, what happens on the next person's death and the next person's death and who dies first, and those things are walking through various disaster scenarios is an important part of estate planning. So for another type of financial account, an investment account, you can also do what's called a transfer on death designation. It serves the same purpose as a pay on death designation, but for an investment account. And it occurs to me now that I don't think I explained pay on death designation. It's simply keeping the ownership in the name of one person, and in the last example, let's use the mom, keeping the account in her name, but instead of making her daughters joint owners, she can make them pay on death owners, which simply means that the bank recognizes a direct designation of beneficiary called a pay on death designee, and that person or those people can then go to the bank after mom's death and take the money out because they are pay on death designees. That type of designation is not available for an investment account, a brokerage account, but for those accounts you can do what's called a transfer on death, which serves the same purpose. Most brokerage accounts do accommodate transfer on death designations. It is very easy and very cheap to transfer a lot of money on death from a brokerage account using a transfer on death designation. And it's something that I think bears discussion with all clients and all family members sitting around the Thanksgiving table to make sure that they understand that you don't need to have brokerage accounts pass through probate. You don't need to have brokerage accounts transferred into trust to avoid probate. You can actually do a transfer on death designation for some of those investment assets. Joint ownership and take on death or registration allow the ownership of the account to pass to the surviving co-owner or take on death recipient without the need for probate. So again, just as with real property, joint tenancy serves the same purpose. On the death of the first tenant to die, the brokerage account would be owned by the surviving tenant. We're going to talk a little bit about life insurance as well. Life insurance in the low income, low asset population is fraught. It's very complicated because sometimes this is the only asset available for burial, for funeral services. Counseling a person who has fewer resources is sometimes more complicated than counseling somebody who has more resources, because each penny counts. And when it comes to burying a loved one, you want to make sure that the insurance is designated properly so the funeral can happen in a timely way and there's not a lot of conflict, and it happens often. So beneficiary designations are contracts. The interpretation is limited to the four corners. There's another first-year law school phrase. As with any contract, the insurance company's form can be modified to suit the policy owner as long as the modification is accepted by the insurance company. And what I mean by that is the beneficiary designation is a form, and you can change the form as long as the company agrees to honor that change. Just for example, here I have two ways of making sure that a beneficiary designation for a minor is honored for purposes of the Uniform Transfers to Minors Act. So if you want a child to be the beneficiary of life insurance, you want to make sure that child doesn't receive the proceeds at age 18, so you can designate a custodian to hold the proceeds for the minor child until they turn 21. And again, that's a free way of keeping money out of the hands of an 18-year-old, delaying the process of receiving those proceeds until they're 21. So the sample designation here says Grandpa Joe, father of the insured, as custodian for Chris Chisholm, child of the insured, under the Maryland Uniform Transfers to Minor Act. The next sample designation simply has the same language but for two children. So if you want a minor to receive life insurance proceeds but you don't want them to get it when they're 18. You want to delay it till they're 21. There's often a way of on the beneficiary designation form to ensure that. Backing up one step here, back to the designating life insurance for funeral purposes. If you do encounter a low resource client who has a life insurance policy and has a plan for burial, a plan that he or she wants to be carried out, it may be wise to advise them to pre-plan so that that life insurance policy is designated to a specific funeral home, or for them to make an arrangement directly with that funeral home aside from that funeral policy. Sometimes people want to designate their oldest child as the beneficiary, so that child will carry out their funeral plans with the proceeds of the policy, in which case on the death of the insured, the child assigns the proceeds to the funeral home. And sometimes the beneficiary does that, sometimes the beneficiary doesn't do that. And so directly organizing your own funeral through the funeral home, I think, is a good option. Children are mostly reliable, but not 100% reliable. And when it comes to burying a parent, that moment of trying to find the policy, trying to get someone to assign it. What if that person has died? Who is the new owner of the policy? Who has the authority to assign it? Those things are complicated and made more so by grief. And so pre-planning a funeral, I think, to the extent someone's willing to do it and able to do it, is important. I just wanted to give you an example here of what a beneficiary designation looks like for life insurance. And this is from a matter that I worked on. You'll see this is the first page on the left is the New York Life Insurance Company death benefit proceed form, and I have circled in red. This was a mom, and she did all the right things planning for her minor child. And she made a beneficiary designation to the custodian, guardian, conservator, or power of attorney. And so on page 1, you'll see in that red circle, she made that check mark. And on page 2, she filled out all the information for her child with respect to the Uniform Transfers to Minors Act. So New York Life Insurance Company has built into its beneficiary designation the option of designating the proceeds to a custodian under the UTMA. And she took advantage of this. She went ahead and put in the name, address, and phone number of the custodian she wanted to manage the proceeds for her son, and she passed away, and it was tragic. Her son was 17 at the time, and in high school, and it was extremely difficult for him for as you can imagine, a lot of reasons. She named her father as the custodian on that life insurance beneficiary designation form. And a check was issued, as you can see here, to the minor on behalf of the custodian under the Maryland Uniform Transfers to Minors Act to the tune of over $100,000. And again, this mom did everything right on her planning. But what happened was Grandpa received the check and then converted it to his own use. And to this date, the grandson, who's now 19, will be 19 next month, he's received about half of the misappropriated funds, and Grandpa's pled guilty to theft and has a judgment for restitution against him. And this goes back to this question for every estate planning client: who do you trust? Who is going to carry out your wishes? And in this instance, Mom named her own father, who stole from her own son, and it was truly astounding and heartbreaking. And just back to the funeral costs, mom's employer paid for her funeral out of his own pocket because he was a good guy, and she had a proper burial, and her dad stole everything. So we're holding his feet to the fire, and hopefully we'll get the rest of the money for her son before too long. Finally, I just want to touch on motor vehicle transfers. Transferring motor vehicles outside of probate is the final frontier, and in Maryland, we think that we've reached it. In 2017, the General Assembly did pass a statute allowing for non-probate transfer of vehicles. Prior to that, the vehicle was sometimes the only asset passing through probate, which you would hope that we could cover all the bases, and now perhaps we can. But prior to that, working with a planning client always included the conversation, well, we can do almost everything here, but your car is probably, if you own a car at your death, it's probably going to have to pass through probate and be subject to all the reporting requirements of the Register of Wills. Here, the statute now in Transportation Article 13115 allows for the transfer of a motor vehicle to a designated beneficiary on the death of the owner. It's a take on death or transfer on death beneficiary designation that's made through the Motor Vehicle Administration. And the one hitch in the giddy up is that it can only be transferred to a single owner. So lots of times we do planning for clients who want to treat all of their children equally, and my philosophy is you should only ever have one child because multiple children always complicate things. And in this instance, if you have just one child, it works perfectly. But if you have multiple children, your car may still be an asset that you want to pass under the terms of your will, because you can only designate a single beneficiary on a motor vehicle, which I think, at least in my experience so far, has been frustrating to my clients who want to treat beneficiaries equally. This is just the website. The MVA is accepting these transfer on death designations via the website. It's the same cost as ordering a duplicate title, because it is essentially a duplicate title. You designate the beneficiary, and then the new title that you receive actually has that designated beneficiary's name on the title as the TOD beneficiary, so that the chain of title is clear, the MVA recognizes it, and they get to collect $20. So it's not as cool as a free beneficiary designation, but it is still pretty cool. And like I told you before, I'm going to just wrap up on last wills and testaments, because everyone needs a will no matter how well you plan. All clients have things that can't be done through probate avoidance, including designating an executor. So estate planning involves making sure your stuff goes to the right place, but it always involves designating people to carry out your plans. In the state of Maryland, the executor is called the personal representative, and we use a will to designate the personal representative. We also use a will to excuse the personal representative from buying a bond to insure against theft, and to pay funeral expenses without court approval. There are funeral expense limitations for small estates, for people who don't have a lot of money. If you have a will that says you're allowed to pay as much as you want for the funeral, then the court can't control it, and that's important to have in your will. Instruction is the payment of any death taxes owed by any legatee. Death taxes are beyond the scope of this talk, but there are taxes owed even by people of minimum resources, and so you want to be versed on how a will can instruct the executor from what resources to pay any inheritance tax that may be owed. Uniform transfers to minor act instructions, nominations for custodians and guardians where there may be minors. The will is the place to make those designations. A will, if executed properly, will help guide whoever is making sure those custodians or guardians are in place. And the recipients and contingent recipients of gifts. What happens if you have a pay on death designee, but that person is deceased? Either the contract governs it, or if there's no contract in place, then the will. And so it's important all the time for everyone to have a will. Wills don't have to be complicated. They simply must be in writing, signed by the testator, and attested and signed by 2 or more credible witnesses in the presence of the testator. So encourage your clients, even if they are excelling at avoiding probate, encourage them also to have a will put in place to take care of all of these other things that take on death and transfer on death and joint tenancy don't address. And so that wraps up my presentation.
Thank you. So we're going to take a few minutes to answer some questions because I see that some have been coming in. So let me just open this. Okay. So some of the questions that we've gotten, someone asked, what is the difference between TOD and POD, which I think you touched on, but.
Right, so a pay on death designation is for financial accounts, bank accounts, and transfer on death designation is for investment or brokerage accounts. So the function is the same, they're just handled in different areas of the article, of the code.
Got it. And someone else asked, what about having a minor child's trust that puts insurance money into the trust and name the trust as the beneficiary?
Sure. So one distinction I want to make is that this talk is geared toward avoiding probate for pro bono clients, so advising folks with limited resources. There are a lot of sophisticated planning techniques and that a planning attorney may want to apply, one of which is creating a trust for children to hold insurance proceeds, creating a trust for children to hold anything. Sort of beyond the scope of this talk, but trusts are great options when you have assets that are being paid to or for the benefit of people who are under, people who are children, like under the age of 18, under the age of 21, people who you may not trust with managing their own assets. The joke is that you create a trust to make up for what is lacking otherwise in the relationship. You create a trust to insert trust into that relationship. And trusts for minors are very common planning techniques in general.
Great. Then we have a couple more. Is the motor vehicle TOD form located on the MVA website?
Yeah, so the slide that shows the MVA website has at the top the URL, and the MVA website walks the user through how to create the take on death designation.
Awesome. And then to answer your question, Victoria, yes, the slides will be made available on our website, and I'm happy to send out an email to all of our participants with that link. But we also just wanted to take a moment to say, if you're not already a volunteer with MVLS, we would love for you to come and join us and do some pro bono work with us. So if you are interested in coming and helping us out, we just want to show you how you can do that. So you go over here to Volunteer tab, and then you click Apply to be a volunteer attorney. And volunteering doesn't necessarily have to be taking a full rep case. You could also help at a clinic. We have a lot of opportunities like that. But yeah, you just scroll down and click Apply Now. It takes you to our online form, and it's super easy to complete. And we also wanted to talk to you about some available cases that we have. We currently have an estate administration case and a city deed case. If you are interested in taking either of these cases or learning more about our available cases, you can contact our Deputy Director, Susan Francis. Her email is sfrancis@mvlslaw.org, and I will also include that in the email if you're interested. We recently started an advanced planning effort, so we're working with the Maryland Faith Health Network and community faith leaders to highlight the need of the community for estate planning for low-income individuals. And our goal with this is really to secure critical resources and remind people that they can access the homeowner's property tax credit, their Baltimore City water credits, and home repair programs that can really change people's circumstances financially. If you want to learn more about those efforts or the new PBRC litigation fund, which now is going to cover estate costs like publication, probate fees, bonding, lien certificate, and recordation fees, you can also contact Susan Francis. And you can also follow us on Facebook and or LinkedIn if you're interested in staying up to date with more webinars and other events we're holding. And after this webinar is over, there will be a quick evaluation. Please take the time to do that. That really helps us learn what you are benefiting from and what we can work on. So thank you so much for attending, and we hope you have a great day. Oh, okay. And if there's any more questions, Alice is willing to stay for a little bit longer. So you can just type them into the chat box if you can think of any more. All right, so we're going to sign off because we're not getting any more questions, but thank you so much for attending, and thank you so much to Alice Young for coming in and talking with us all about probate.
My pleasure.